This is Barry Selma speaking for Claims School Incorporated's blog, Selma on Insurance. Today we're going to talk about the need for pre-suit notice to a hospital in the state of Mississippi and many other states, and why failure to comply with the Tort Claims Act requirement of notice to a hospital before suit will defeat your suit. In April, Holifield and Jeffery Holifield versus Highland Community Hospital, the Court of Appeals of Mississippi on April 15, 2025, highlighted the issues surrounding proper notice under the Mississippi Tort Claims Act and the relationship between HCH and Forrest General Hospital, FGH. The Holifields filed a medical negligence complaint against HCH on April 5, 2023, for injuries sustained during a procedure on November 5, 2021. Prior communication with HCH's insurer was initiated by their attorneys in January of 2022. A notice of claim letter was sent to HCH on October 5, 2022, but there was uncertainty regarding its receipt, and after discovering a change in administration, a new letter was delivered to the current administrator on October 28, 2022. HCH moved to dismiss the claim and the case on May 24, 2023, claiming it is not a separate entity from FGH and thus not capable of being sued under the MTCA, or the Mississippi Tort Claims Act. The plaintiffs sought to amend their complaint to substitute FGH for HCH, asserting that both entities received proper notice. HCH countered that FGH had not received any notice and the statute of limitations had already expired. The Circuit Court denied the motion to amend on October 30, 2023, stating that HCH is a division of FGH and that the plaintiff failed to serve proper notice to FGH's chief executive officer before the statute of limitations expired. The Court of Appeal concluded that both of the trial court's rulings at issue on appeal required a determination whether the Holifields properly served pre-suit notice on FGH in accordance with the Mississippi Tort Claims Act. One does not have to be a lawyer to sense that the organization funding and operation of Memorial Hospital at Gulfport are matters capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. In the context of an MTCA case, pre-suit notice either does or does not occur prior to the filing of a complaint. There is little that can be pleaded in an amended complaint that can cure the failure to give pre-suit notice of an MTCA claim. The Holifields did not provide the statutorily required notice to FGH under the MTCA, and the Court of Appeals concluded the trial court did not err in denying the motion to amend the complaint. So the Court of Appeals affirmed the dismissal, emphasizing that the failure to provide notice under the MTCA warranted dismissal of the case with prejudice. The Circuit Court had granted HCH's motion to dismiss or for summary judgment and entered a final judgment of dismissal with prejudice on October 31, 2023. The Circuit Court also addressed the Mississippi Supreme Court's recent holding in University of Mississippi Medical Center versus ACOC, a 2023 decision of the Supreme Court that, although the plaintiffs there had never filed the statutorily required notice with the hospital's chief executive officer, the case could be remanded to allow plaintiffs an opportunity to establish equitable estoppel or waiver based on the medical center's conduct by competent evidence. The trial court concluded that ACOC was distinguishable because the Holifields had no communications with FGH, only with a claims representative working on behalf of FGH, and HCH committed no acts or made no communications which could have given plaintiffs occasion to say they relied upon such acts or communications in good faith or to their detriment, and so the plaintiffs lost. States like Mississippi enacted statutes limiting suits against doctors and hospitals unless the plaintiff first gives written notice to the defendants of the intent to sue and providing an opportunity to create a place where an early settlement could be reached. The plaintiffs failed to give notice to the correct parties before filing suit, a statutory condition precedent to maintaining a suit against the hospitals, and the appeal ended up affirming the trial court's decision. This video was adapted from my blog, Zelma on Insurance, which is available to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes, and you'll receive access to the more than 5,050 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.